Hello, everyone. My name is Ariella Wagner. I'm the founder of SunRay Construction Solutions. Today, we have a fabulous webinar. Are you ready for the Texas lien law changes? So finally, there are these fabulous changes. Today, the webinar is going to be conducted by Emily. She is a brilliant construction attorney. And if you have any questions, this is your time to ask them. But without further ado, I would like to introduce Emily Pendleton. Pardon me, Emily Pendleton.
Thank you all. Thank you, Ariella, for that warm welcome. I'm Emily Pendleton. I'm an associate with Porter Hedges in the construction litigation practice group. And I'm here to talk to you guys about the significant changes that are going to be coming up in 2022 to the Texas lien laws. And they're quite exhaustive. A very, very relevant topic right now to stay apprised of. And so I hope at the end of this that we are able to have answer some questions towards the end of the presentation. And so please do ask them, and we'll try and squeeze them in at the end. Like I said, there are a lot of them. And so here is a list of some of those changes that we're going to be going over here today. The Texas legislature, they've been busy at work making these changes, and they're primarily focused on streamlining subcontractors and suppliers, and particularly the lower tiered subs, abilities to perfect their liens on private non-residential construction projects in Texas. And so these changes are focused today. We're going to be talking about the private side, not the public side, and non-residential construction projects in Texas. So these are the topics that we're going to be going over today. These are sort of some of the key changes, but by no means is this an exhaustive list. If it were, we'd be here all day. And so do keep in mind that these are just some of the highlights, but keep in touch with me, keep in touch with Ariella about the other changes that have occurred to Chapter 53 of the Texas Property Code. All right, and let's get started. So when do these changes go into effect? That's really important because these changes that we're going to be talking about throughout the presentation today only apply to projects with original contracts entered into on or after January 1st of 2022. Okay, so these original contracts are the contracts between the owner and the general contractor. So we're going to be experiencing sort of this limbo period where you find yourself entering into contract agreements, performing work in early 2022, but you provide your services somewhere in the middle of the project. And so perhaps the project actually started back in 2021. So you're going to need to be cognizant of when that original contract was entered into between the owner and the general contractor kicking off this project. And so my recommendation going into 2022 is to, be sure to utilize your leverage as you enter into those purchase orders and those contracts going into 2022, and ask the general contractor or the owner, when did this project get started? When did you enter into the contractual agreement with the general contractor to start this project? Okay. Forms. Okay, so this is a big change from prior lien law, and previously there was no standard form, pre-lien notice forms for unpaid subcontractors and suppliers. We would just generally state how much the claim amount was, who you were under a contract with, and there was this required magic fund trapping language that we would insert into all pre-lien notices. If the claim remains unpaid, the owner may be personally liable and the owner's property may be subject to a lien unless the owner withholds payment from the contractor for payment of the claim, or the claim is otherwise paid or settled. And so this magic language would essentially trap funds in the hands of the owner. So going forward now, the Texas legislature has put forward 2 statutory forms that are all subcontractors who send out pre-lien notices will need to comply with substantially. And there's 2 different forms, one for unpaid labor and materials, and 2 for unpaid contractual retainage. And I know that oftentimes those can be you might have both unpaid labor and materials as well as unpaid contractual retainage. And so these forms can easily be combined. So let's take a look at the examples of these. Okay, so here we have the form that's in the statute now going into 2022 for unpaid labor or materials. And you'll see at the start, there is this warning. This notice is provided to preserve lien rights. Owner's property may be subject to a lien if sufficient funds are not withheld from future payments to the original contractor to cover this debt. Okay, so this warning is essentially the new quote unquote magic language that covers the funds trapping language that was used previously and required to be in your pre-lien notice. Okay, and so then the remainder of you have some line items here that need to be included in your pre-lien notice for unpaid labor or materials. All right, and so now we're looking at the example of the form pre-lien notice for unpaid retainage. This is the unpaid contractual retainage notice. And the only difference here is the fact that there is a line item for the total retainage unpaid amount as well as the claim amount. And so as you can see, these 2 forms are substantially similar, and so they can easily be combined. And I have an example here up on the screen for a combined notice where you have a notice for claim of unpaid materials, labor, and contractual retainage. And so very simplistically, you can add in a line item for the total retainage unpaid. And then you have in your claim amount, of course, the unpaid retainage as well as your unpaid materials and labor amount for a total claim amount. You never want to send out one of these notices and leave something on the table, right? And so to the extent you have unpaid materials, labor, and contractual retainage that's outstanding, you want to be sure and notify the owner and general contractor of all outstanding amounts. Okay. So now that we've talked about the changes in the forms that are to be used going forward, let's talk a little bit about the changes that are occurring to the deadlines for sending out these forms, as well as filing your lien affidavits in the real property records. Okay, so just taking a step back, we talked about the lien notice for unpaid materials and labor, and the lien notice for unpaid contractual retainage. There's different deadlines that apply to each, and so we're going to be talking first about the changes to the deadlines that apply to unpaid materials and or labor. So previously, Texas law used to make a distinction between first-tier subcontractors and second-tier and lower contractors. So they would require first-tier subcontractors to send out their pre-lien notices by the 15th day of the 3rd month after performing their work that remained unpaid. Whereas second-tier subcontractors had much shortened deadlines and had to comply with the 15th day of the 2nd month after providing labor or materials for which they had not been paid, right? And so that was a really cumbersome deadline to meet, and the Texas legislature recognizes that. And so now going forward in 2022, original contracts that is entered into January 1st of 2022 and onward, the lien laws no longer make a distinction between the first tier subcontractors and the second tier subcontractors. They all have the exact same notice, pre-lien notice deadlines. They're all going to be required to send out their pre-lien notice by the 15th day of the third month after providing labor or materials for which they have not been paid, which is really, I think, a big help and in streamlining the process and the ability for lower tiered subcontractors to perfect their lien rights. All right, so looking at this new updated chart that we have, excuse me. So let's assume you performed your work in August of 2022. The project started in February of 2022. First tier and second tier and all tiered subcontractors would be looking at making sure to send out their pre-lien notice by November 15th of 2022. So long as you completed your work, if you finished your work in August of 2022 as well, then you would be looking at filing your lien affidavit by December 15th of 2022. Okay. Okay, now, so we're going to switch to talking about deadlines for contractual retainage. So on the pre-lien notice side of things, you'll want to send out your pre-lien notice for unpaid contractual retainage to the owner and general contractor most often within 30 days after completion of your work. That's going to be the most common example of your deadline to send out your notice to the owner and general contractor of unpaid contractual retainage. And so sometimes in the event that you are terminated or abandon the project, you're still looking at 30 days after that for sending out your pre-lien notice. And in the unlikely event that you get wind of the general contractor being terminated or abandoned, you're going to need to send out your pre-lien notice of unpaid contractual retainage within 30 days of that date as well. But most often you'll want to send notice to the owner and general contractor, notice of unpaid contractual retainage 30 days after completing your work. Okay, so then we have a change to the date in which you want to file your lien affidavit for purposes of unpaid contractual retainage. And that date per the new statute is 30 days after completion, termination, or abandonment of the original contract. So you'll need to keep apprised of the status of the project in order to be familiar with when this deadline falls to get your lien recorded. And this is an or. Subpart B says, or you'll need to file your lien affidavit by the 15th day of the third month after the month in which the original contract was completed, terminated, or abandoned. And so this or is a little bit wonky in the sense of, well, of course, the 15th day of the third month after the original contract was completed, terminated, or abandoned is always going to be the later of the two deadlines. So if it's an or, I'll just comply with that. And that is technically what the law is. However, I would always recommend going ahead and getting your lien on file, as well as sending out your pre-lien notices within 30 days of project completion. Of course, if your deadlines fall prior to that, comply with those deadlines. However, you'll always want to get your lien recorded within 30 days of project completion because of the concept of fund trapping that we talked about earlier. So let's take this hypothetical. Your work is performed at the end of the project. Say you're a flooring subcontractor and you perform your work at the very end of the project. Project reaches substantial completion after you finish, owner moves in, and final completion occurs shortly thereafter. and you think, well, even if my invoices remain unpaid, I have until the 15th day of the third month to send out my notice, and the 15th day of the fourth month to record my lien affidavit. Well, that's technically not accurate if you want to put yourself in the best position to ensure that the owner has trapped funds to satisfy your claim. And so the owner is technically authorized to release the reserved funds, release the 10% statutory retainage that it's been withholding from the general contractor. They're entitled to release this money 30 days after final completion. So if you're waiting until the 15th day of the third month to send out your notice for your unpaid flooring work or materials that you provided, then you might be too late to trap those funds in the hands of the owner, because they've ultimately already released that money to the general contractor. And so that's why these deadlines are important to comply with, but also understanding the timeline of the project is going to be very, very important. All right, so let's talk about calculating statutory deadlines. So previously, the 15th day of the third month, even if that fell on a Saturday, Sunday, or legal holiday, you are going to be required to comply with the prior business day. You'd need to send out your, say the 15th day fell on a Saturday, you were going to need to send out your pre-lien notice by that Friday in order to comply with the statute. That is no longer the case anymore. Now, if the deadline happens to fall on a Saturday, Sunday, or legal holiday, the deadline is extended to the following day that is not a Saturday, Sunday, or legal holiday. So what deadlines does this apply to? We're talking about pre-lien notices, the 15th day of the third month. Those will be extended to the next day that is not a Saturday, Sunday, or legal holiday. Your post-lien notices, these are the notices to the owner and general contractor that you have recorded your lien affidavit and you're sending them notice of that recorded lien affidavit within 5 days. If that 5th day happens to fall on a Sunday, you're given until the following Monday, assuming that's not a legal holiday, to send out your post-lien notice. And then this will also apply to lien recordings. I know that oftentimes I've encountered clients that come to me, and it's the 17th because it's the Monday after the 15th, which fell on a Saturday, and the county clerk was not available on the weekend to record a lien affidavit. Now our lien recording deadlines have been extended to the following day that is not a Saturday, Sunday, or legal holiday, to the extent that that deadline falls on a weekend or legal holiday. But ultimately, my continued recommendations to all of my clients are don't wait, act fast and act early, because there's no real reason to wait until the very last minute to do any of these things, because once you file your lien or send out your pre-lien notice, you can always retract your claim. Retract your claim or release your lien once it's been satisfied. But as soon as you miss the deadline, you've missed the deadline, and those can, those are hard to fix. All right, so mailing. There are now expanded mailing options for notices. So previously, certified mail was pretty much the only recognized acceptable form of mailing lien notices. UPS and FedEx services were not recognized forms of delivery. And so currently, the status of the law going into 2022 is that certified mail continues to be the preferred method of mailing. And that is primarily focused on the fact that because if you send your pre-lien notices out via certified mail, you've complied with your obligations for ensuring that your pre-lien notices were deemed, delivered. You do not have to ensure receipt of the pre-lien notice by the owner and the general contractor so long as it's postmarked by USPS by the deadline. And so you might ask, well, what's new if certified mail continues to be the preferred method for mailing lien notices? Well, the lien laws expand the acceptable forms, so you can send out your lien notices via FedEx and UPS or other private delivery services with tracking capabilities. And so long as they are delivered to the owner and general contractor, you will have complied with your obligations to send your pre-lien notices. But like I mentioned, certified mail is still the preferred method. So why does it matter? Well, it matters because of this continued concept we keep talking about called funds trapping. Funds trapping are only trapped in the hands of the owner upon receipt of a lien notice. So in that circumstance, receipt is very critical. And as we all know, FedEx and UPS tend to have faster delivery times than the US Postal Service. USPS, I've found, can take anywhere between 7 to 10 days to deliver your pre-lien notice to its destination, whereas FedEx and UPS, if you send it priority mail or overnight, you're going to get a much faster delivery. And so long as that pre-lien notice is received in the owner's hands sooner rather than later, you have more of an opportunity to trap those funds in the hands of the owner before they release the funds to the general contractor. Okay, so practice tip going forward, I would highly recommend continuing to send your pre-lien notices via certified mail, as well as FedEx and UPS, just to get it there that much faster. All right, filing suit. So this is a very significant change. Previously, claimants who had filed a lien had at least 2 years to file suit to foreclose on a perfected lien. And oftentimes, owners would evaluate a lien on their property and say, well, I don't plan on selling my property for the next 25 years, so this lien really means nothing to me. And so subcontractors and all contractors were required to go ahead and file their lawsuit for lien foreclosure in order to recover funds. And previously, like I said, you used to have 2 years time span in order to file that lawsuit. Now, lien claimants have 1 year from the last date the claimant was permitted to file its lien affidavit to institute its lawsuit in the county in which the project is located. There is this extended period that can occur of up to 2 years if the claimant enters into a written agreement with the property owner, and that written agreement is recorded in the real property records in the county where the property is located. And I would just always err on the side of the property owner probably isn't going to enter into any sort of written agreement extending your statute of limitations time period for filing a lawsuit against them. So you really need to make sure to comply with the 1 year deadline of instituting your foreclosure action in court. Okay, and last but certainly not least, we're going to talk a little bit about lien waivers. So going forward in 2022, we had these 4 different kinds of lien waivers that were often used and recognized by Texas law as valid lien waivers, both conditional and unconditional lien waivers, as well as progress payment lien waivers and final invoice lien waivers, right? And so no longer is it a requirement to have your lien waivers notarized and be a valid lien waiver under Texas law. And so I know that a lot of times clients would say that, you know, it's a huge burden to have to submit your monthly invoice with a notarized lien waiver. I'm always having to track down the local notary in my company, or, you know, go to the bank in order to get my lien waivers notarized. And so that's no longer a statutory requirement for a valid lien waiver. And this applies across the board to the 4 different kinds of lien waivers. And so, but that's not necessarily to say that owners and contractors may continue to require that their lien waivers that you submit with your invoices be notarized per the contract terms. But that's certainly a negotiable item now that the statute no longer requires it. And that's also not to say that, you know, county clerks who might be recording lien releases or lien waivers will not continue to require that your lien release be notarized for purposes of recording. Okay, and with that, I hope we have about 3-4 minutes. I'm happy to stay longer if you have more questions, but that covers, you know, the key changes that will be implemented going forward in 2022.
Emily, you did such a fabulous job. And I know that if everyone could speak right now on the webinar, they would probably say the same exact thing. And I'm sure everyone would be like, thank you so much.
No, it was a pleasure, and I know I covered things really, really quickly, and y'all might have questions for me, for Ariella, and we're happy to answer them, and I'm happy to answer them maybe more eloquently than I stated them the first time.
Well, you did a really fabulous job, and let's see if we do have any questions. Actually, someone said, yes, thank you very much. And to everyone on the webinar, we will absolutely be sharing the recorded webinar. It will go out in an email to everyone that's attending. In addition, we'll send out the new timelines. The SunRay application will contain, of course, all of the forms, so you do not need to worry about that. I am a big fan of Porter Hedges. Allison Schneider is the attorney that SunRay worked with for many, many years. And now we're working with Emily, who's just spectacular. They're a great law firm. And I'm honored to work with such a fabulous attorney. And Emily, we're going to hopefully do some webinars. We can't give out those dates yet because we have some exciting news with Emily. Emily is, God willing, due, I think in February.
Yes, I'm due. Baby boy coming in February of 2022. So I've been evasive of finalizing my 2022 schedule, but please stay tuned. I look forward to continuing to work with Ariella and helping with these webinars and helping make sure that you mitigate your risk on construction projects by making sure that you file your lien and bond claims appropriately.
Emily, you are truly fabulous. And you did a great job, and I want to thank you very much. And to everyone attending, I wish everyone a fabulous rest of your week, and of course, a happy Thanksgiving to you and your families. And again, if you have any questions at all, our contact information is below. And wishing again, happy Thanksgiving to everyone. And thank you again, Emily.
Thank you all. Happy Thanksgiving.